Okay, this is the final video of the three-part series discussing the last three chapters covered in this hospitality law class. Um, the first video being that from chapter 9, discussing negligence in general and starting to discuss your duties of care owed in light of negligence, and then the standard of care and acting reasonably prudent under certain circumstances. Then chapter 10 in video 2, we discussed more about expanding on some of those duties that you have to guests as a hospitality operator to the cover under, that first element of negligence and duty of care. So we expound a little bit more on some more of those duties in chapter 10 and starting to discuss a little bit more about who constitutes a guest and who you would actually owe those duties to. Now, finally, in this third video, we're going to discuss your responsibilities in serving food and beverage specifically. Some of that is rooted in negligence. A lot of it's rooted in negligence, but there is a little bit that's rooted in statute as well as contract world. So if we go back to chapters 4 and 5 in my videos there, I discussed a little bit about the Uniform Commercial Code and how that governs the sale of goods, and common law just governs other contracts. But the sale of goods is what you're effectively doing if you're serving food and beverage. And it has been held that although, yes, there is a service component, at the end of the day, the UCC will be looked to with regard to the sale of food and beverage in a restaurant. So anyway, what that means for you in terms of your responsibilities here is knowing that you have to provide food and beverage that is merchantable under the eyes of the UCC, because under the UCC, as a hospitality operator, you are considered a merchant, which then means you have to sell food and beverage that is what's considered to be merchantable. Merchantable means suitable for buying or selling. So you have to serve food that's suitable for buying or selling, and that's what's called the implied warranty of merchantability. Discuss that a little bit in chapter 4, I believe, chapter 4 video covering contracts. I also mentioned the implied warranty of fitness for a particular purpose, our purpose being consumption. So you have to provide food and beverage that's fit for consumption. So you have those two implied warranties that are more rooted in contract world than negligence. So if you have, let's say, someone who gets sick and gets food poisoning when you're serving food, then they're going to bring a couple of claims. They're most likely going to bring a breach of the implied warranty of merchantability. They're going to bring a breach of the implied warranty of fitness for a particular purpose, because if it's undercooked and it makes them sick, obviously it wasn't fit for consumption. Similarly, it wasn't fit to be bought or sold. And then, of course, they're going to bring negligence claims that you were negligent somehow. There was a cross-contamination that happened, or if you go back to our earlier videos in this three-part series where I talked about reasonably prudent, and I believe it was chapter 9's video, discussing the reasonably prudent thing to do would be to temp the chicken before it goes out to make sure it's the standard 165 degrees that's recognized to be safe. If you didn't do that and somebody got sick and you didn't exercise safe practices and didn't act reasonably prudent, now we've also got negligence claims. So it's not like you just get sued for one or the other. You're going to get named all of those causes of action in a lawsuit, those breaches of the implied warranties I mentioned, and negligence. So just quickly, if you research, if you haven't already heard about the McDonald's hot coffee case, it's an infamous case where an elderly woman suffered severe third-degree burns from hot coffee from McDonald's. It got in her lap and she was hospitalized, had to undergo surgery. It was really traumatic. Her actual expenses were quite extensive, and she got a huge punitive award from the jury, which the judge later actually reduced, and then ultimately McDonald's and the plaintiff settled because they were going to have to appeal and whatever. Anyway, what was alleged and what was found where McDonald's was held to be liable was a breach of the implied warranty of merchantability, because they're saying that hot coffee served at that temperature is not merchantable, so it could not be bought or sold, or it wasn't, merchantable, not being able to be bought or sold. And that it also was the breach of the implied warranty of fitness for a particular purpose, because coffee that hot is not fit for consumption, not when it gets to be near boiling, basically. And so those were among the causes of action that were brought, and that the jury felt that McDonald's had breached. But then they were also on the hook for negligence, not acting reasonably prudent, not acting like a reasonably prudent restaurant operator in serving coffee, because they were serving it so hot and actually had it in their policies to serve coffee that hot, and had disregarded, I think it was about 700 other customer complaints about the hot coffee being too hot. So a reasonably prudent restaurant owner, under the circumstances, according to the jury in this case, said that they would not have continued to serve coffee that hot, and therefore were found negligence. Now, obviously, I'm like distilling this way down. There's more to it, but that's the essence of this. So that's a real world case where you can see this applied. So that covers those implied warranties that you'll see covered in the slides, but I really wanted to expound that and connect the dots for you, because I don't think that necessarily would have been connected otherwise without that explanation. You also have a duty to be truthful in your menu and how you advertise the ingredients and the cooking methods and all of those things. You cannot be deceptive. You can't lie. That's what they call truth in menu. So there are, if you look up truth in menu laws, particularly in the state of California, you're not going to find a statute that says truth in menu. That doesn't exist. But what those laws are based typically in fraud, unfair competition, false advertising. That's where the meat of those truth in menu laws are. So you have a responsibility to be truthful in your menus and what you're selling. So you can't say that you're sourcing salmon from this particular place, or let's say it's a wild salmon, which we all know tends to be more expensive, but you're actually serving basic farmed Atlantic salmon. You can't say that you're serving this when you're actually serving that. That is fraudulent, it's misleading, and it's deceptive in business practices, and you can get into serious trouble for that. There are cases that are in somewhat recent history, in the last, I'm guessing, I think 5 years or so, where a district attorney even got involved in San Francisco against a restaurant because they were saying that a type of fish was something that it actually was not. And so they not only were liable on the civil level for truth in menu, but then they were also got the attention of the district attorney. So they faced criminal charges as well. So be truthful, no fraud, just be honest about what is in your menu and what you're serving. And same thing for beverage. Don't say that it's a particular brand if it's not. So and that you could run afoul of other state laws as well. But in terms of truth in menu, that's what we're talking about here. You also have specific laws in terms of serving alcohol beverages. So food we just covered, but now I want to touch on beverage a little bit, and in particular alcohol. The federal government, through the 21st Amendment, passed on the ability to the states to pass their own alcohol laws. So alcohol laws are going to be specific state to state, and typically are managed by what's called an Alcohol Beverage Control Agency, or the ABC. In California, we have the ABC and we have the ABC Act. So we have the ABC agency that enforces the act, and then we have the act itself, which are the state laws, and getting licenses to be able to sell alcohol and whatnot. But there are some things that I really want to touch on here. California is really big on not serving alcohol to minors. So you have a responsibility among all of the other laws to maintain your license and have it properly and to legally sell alcohol. Assuming that you've done all that, you also have an obligation and responsibility to not serve minors. That is a big one. So you have a responsibility to follow the law here. And then, so you have laws that you can break if you're not serving the alcohol properly and selling it properly. But then you also have the negligence theories as well to the guests and to employees. So you've got the government, the responsibilities to the government and not violating the law set forth with alcohol. But then you also have the duties to guests and employees when it comes to serving alcoholic beverages. And the biggest one here that I want to touch on is not over serving. And that is a big responsibility that you have, is to not over serve your guests alcohol. The thing here is that you have what's called a third party liability exposure. So let's say someone is in your establishment and they get overserved. And then they leave your establishment and they get into a car accident and they hurt somebody, seriously hurt somebody. And now that plaintiff wants to sue because, you know, they have medical bills and have suffered a harm, as we talked about in negligence. The plaintiff has to have been injured or suffered a harm. Well, in this case, we're going to say, yes, they were injured and they suffered harm and they had medical bills. So they are damaged and injured. So number 4 of the elements of negligence are met, right? Now what's a little less clear are the first 3 elements of that if they try to sue you, because you're not the one who got behind the wheel of a car drunk and hit them. So and what duty of care did you actually owe them? Because if you recall the videos before, I said you have a duty of care to your guests. Some random driver out on the freeway was not one of your guests, right? So you're looking at me and be like, Professor Sailing, how on earth could I even be named in a negligence action or an action period if I didn't even owe them a duty of care? And I would say that you're right. So because of that, state said, we're going to put the responsibility on the people serving the alcohol and pass a statute, because those first 3 elements are going to be really hard to prove in a normal negligence action, even though you may have been negligent in over serving the guest. The thing is it was the guest that caused the accident. The guest owed the person that they hurt a duty of care by virtue of driving on the road. If you drive on the road, you owe other drivers a duty of care to drive safely, and driving drunk is not deemed to be driving safely. So yes, the person who caused the accident and was drunk driving absolutely can meet those elements of negligence for our purposes here. Let's say, assume that they can. But what's less clear is how the bar would meet those elements of negligence. They really don't. So state said, we want to put the responsibility still, though, on the hospitality operators to not overserve their guests. So what we've done is we've passed what are called dram shop laws and use a third-party liability theory, which means that if you overserve your guest and your guest goes out and causes an accident and hurts someone else, that person can in fact sue you and use a violation of those dram shop laws as a method by which to do so. Now, just like I mentioned before, the laws vary by state. It's not, like I said, the federal government gave the states the power to pass their own state laws and regulate the sale of alcohol. So these dram shop laws are not one size fit all based on every state. So each state has their own set of dram shop laws and what their carve outs might be. In some cases, it might be not just over serving anybody, but over serving a minor or over serving someone who's known to be kind of like the town drunk, if you will, who's known for over imbibing, has a reputation for that. Those might be some limits that are put on those dram shop laws, whereas other states might have like very broad dram shop laws where it says, I don't care who it is. If you overserve, you overserve. And so now you're going to be on the hook. Like I said, it's going to vary state to state, but that's the essence of the dram shop laws and their basis in there. So just a couple of things in closing on how to mitigate your liability, which is what I like to do in each of these videos. I talk to you about what your exposures are and your duties, but then I want to let you know ways you can mitigate that liability. Obviously, don't overserve your guests and serve food that's fit for consumption, or hot coffee. Make sure that it's actually not too hot for consumption. That's kind of a no-brainer, right? But ways to do that is through proper training. Properly train your employees. Make sure that you hire qualified employees who know to cook a chicken breast at 165 degrees, and that they also know how to temp it and help avoid some of those situations where someone could get hurt. So training is key. Proper hiring procedures are key. A couple of things as it relates to serving alcohol specifically is having your people who are serving alcohol takes a formalized training program like TIPS or the Serve Safe Alcohol, just to name a couple. They have the market cornered on that. They know exactly proper training methods and are well recognized, so that if something, God forbid, did happen, you can say, hey, we did train our employees using these particular services that are widely known, and going back to standard of care, our industry standard. So did you act reasonably prudent under the circumstances? You owed a duty of care to this person. You had a standard of care. Industry standard is having your people serving alcohol be trained by TIPS or ServeSafe or one of these big organizations that are widely known in the industry. And that helps cut in your favor of acting reasonably prudent. So anyway, training, and also management overseeing your employees in these situations, and then disciplining your employees properly if they are violating these procedures. Let's say they did overserve or accidentally serve to a minor or whatever, however you're doing these written warnings, and then ultimately maybe needing to terminate if it comes to that, because you need to hire responsibly, and you also don't want to be on the hook for negligent retention either. So anyway, that wraps it up for this 3-part series. And I will post what the assignment requirements are in announcements and in the modules. All right.